Hey everyone, welcome back to Corporate Decoder, the place where we try to make sense of all the corporate jargon and numbers. Today we're diving into a company that's had to get a court order just to hold their shareholder meeting, which sounds like it's going to be an interesting one. Before we get started, if you like getting these clear breakdowns of company filings, make sure you're subscribed and join our Discord community linked in the description below where we discuss these things in more detail. This filing is all about a company called Charles & Colvard Limited. They're letting everyone know about their upcoming shareholder meeting, but also revealing some pretty unusual circumstances surrounding it. It seems like things haven't been smooth sailing for this company, and they've had to involve the court system to get their annual meeting organised. So what's the big deal? Well, on August 13th, a judge named Michael L. Robinson in North Carolina stepped in and issued an order. This order is essentially telling Charles and Colvard Limited exactly when and how they need to hold their 2025 annual meeting of shareholders. It's not exactly a vote of confidence in the company's usual meeting planning process, is it? The company itself is incorporated in North Carolina, and they have a commission file number of 000233329. Their IRS employer identification number is 561928817. These are just the standard identifiers. The important stuff comes later. The court order specifies that the meeting will take place on Monday, October 13th, 2025 at 9:30 a.m. Eastern Time. They also set August 29th as the record date, meaning if you own shares on that date, you're eligible to vote at the company's main office. Now, here's where it gets really interesting because the date of this annual meeting has been pushed back by more than 30 days compared to when they usually hold it. It affects how shareholders can submit proposals. Normally, if you want to get something into the company's official meeting materials, there are strict deadlines. You'd have to get your proposal to the corporate secretary by a certain date for it to get your proposal to the corporate secretary by a certain date for it to be considered. In this case, that deadline was August 25th, however. And this is a big however. The court order limits what can even be discussed and voted on at this meeting. They can't just accept any shareholder proposal. It's as if the court has taken control of the agenda. This is a pretty rare situation where the company is explicitly stating they cannot accept shareholder proposals for this meeting, even if shareholders follow the normal rules. So while the deadline for proposals was August 25th, the company is saying it doesn't matter because the court has restricted the topics. The company is also checking a box here indicating that this filing might be serving as soliciting material related to proxy voting rules. This is a technical detail, but it shows they're navigating specific regulations for how they communicate with shareholders about the meeting. So what exactly can be voted on at this court-mandated meeting? The order clearly lays out the agenda. First, it's the election of the company's board of directors. The company has named its current directors as their nominees, Rutan Banderi, Annan Butler, Neil Goldman, Don O'Connell, and James Tu. Then they will vote on ratifying the company's independent auditor. This is the standard procedure to make sure the company's financial books are in order. They'll also have an advisory vote on executive compensation, which is often called a say-on-pay vote, and an advisory vote on how often shareholders should get to vote on executive compensation. These are important votes for shareholders to voice their opinions. Even if the executive compensation vote is usually advisory, the court order also changed how a quorum is determined for this specific meeting. A quorum is the minimum number of shareholders needed for a meeting to be valid. Normally, this is based on a certain percentage of outstanding shares, but here the order states that simply having shareholders show up, either in person or by proxy, will count towards the quorum. This might make it easier to officially conduct business, even if fewer people attend than usual. Now, we aren't given much detail about the financials in this particular filing, as it's more procedural and focused on the meeting. However, there's a hint of potential conflict here. The company mentions that River Sykes Fund LP, a shareholder, might try to put its own candidates on the board of directors. This suggests that there might be some disagreement or pressure from shareholders about the company's direction or management. It's probable that the need for a court-ordered meeting stems from some underlying governance issues or disputes. The filing also includes the actual court order as an exhibit. This order is the legal document that mandates this entire process. It's the backbone of why this meeting is happening under these specific unusual conditions. As for the company itself, Charles & Colvard is primarily known for its manufactured gemstones, particularly moss and nite. They've been around for a while, trying to carve out a niche in the jewelry market with these alternative stones. However, the jewelry industry can be quite competitive and sensitive to economic downturns. The fact that they needed a court to step in for their annual meeting might signal deeper problems, perhaps relating to shareholder activism, management disputes, or even financial struggles that have led to a breakdown in standard corporate governance. Without actual financial tables in this report, it's hard to give a deep dive into their numbers, but the context of needing a court order and the mention of a shareholder potentially seeking to elect new directors strongly suggests that the company might be facing internal strife or pressure from investors who are unhappy with its performance or strategy. It's a sign that things aren't running as smoothly as they should be in a typical public company. So what's my take on this situation for Charles and Colvard? Well, the need for a court-ordered meeting is a significant red flag. It usually points to a failure in communication or agreement between the company's management and its shareholders, or possibly internal disputes among the board itself. The fact that they've had to go through this process suggests a level of dysfunction. The mention of River Styx Fund possibly nominating directors further supports the idea that there's a power struggle or a need for change in leadership from the shareholders' perspective. This can be a positive if it leads to better management, or a negative if it causes more instability and distracts from the core business. We don't have the financial numbers here to see if past performance is driving the shareholder activism, but it's a very common reason. My assessment is that Charles and Colvard is likely facing significant challenges. The direction the company is heading seems to be a point of contention, and the company's governance structure might be under pressure to improve. The opportunities for shareholders lie in potentially electing a more effective board, but the risks are continued instability and a focus on internal battles rather than business growth. For now, without seeing their actual financial results, it's hard to say if they're truly struggling financially or if this is more of a governance battle. But any company that needs the court to organise its basic shareholder meeting is definitely not operating under normal, healthy conditions. We'll have to keep an eye on their future filings to get a clearer picture of their financial health and how these governance issues are resolved. Alright, that's our breakdown of Charles and Colvard's latest filing. What's your take on these numbers and what they signal for the company's future? Drop your thoughts in the comments. If this analysis was valuable, hitting that like button really helps, and subscribe for more deep dives. Don't forget to check out the Discord in the description. Thanks for watching. See you next time.